In this matter, People v. Grimes, we welcome the Honorable Lori D. Zelon, Associate Justice, Court of Appeal, 2nd Appellate District, Division 7. Mr. Gardner, you may proceed.
Good afternoon, Your Honors, and may it please the Court, my name is Cliff Gardner. I represent Appellant Gary Grimes. I'd like to focus my remarks this morning on the two issues covered in the supplemental briefing that the Court has asked for. The question of forfeiture, that is, whether the State, by failing to brief harmless error and raising it at oral argument, has waived or forfeited the issue. And second, if they have not forfeited it, or if they have and it's excused, whether the error in this case was harmless. Let's start with the forfeiture argument. The case was originally argued in May, I think it was May 28th, and the State does not dispute that if I had come to that oral argument and urged the Court to reverse my client's conviction based on a claim that I had not briefed, that this Court's precedents would prevent me from doing that. The State doesn't dispute that, and I think that's a fair and appropriate limitation. Implicit in the State's argument that this Court should now resolve the merits of the harmless error argument is the idea that these same precedents don't apply to the State. And the State is free to come to oral argument and for the first time raise an argument and urge affirmance on the basis of that argument. And I'd like to make just a couple of additional comments in my time this morning about that position. And the first is to focus the Court or emphasize what I touched on in the briefing, and that is the case law. And this isn't the first court to have to address the question of whether the State, by failing to brief harmless error under Chapman, forfeits the issue. I think there's 13, 14, or 15 jurisdictions that have addressed it, and I've cited them in the supplemental briefing.
Do they have a provision in their Constitution similar to the one that we have?
The miscarriage of justice provision, Your Honor? Well, many of those cases are federal cases, and so the answer is no. I don't know that there's a miscarriage of justice clause in the federal Constitution. As for the Nevada and Maryland cases, I'm not familiar with them. But the miscarriage of justice...
So let me follow up on that. It could be argued, and I want to give you a chance to push back against it, that the provision in our Constitution is a limitation on our authority, that a conviction shall not be overturned unless the miscarriage of justice standard is met. I don't understand you to be arguing that in every case the Attorney General argues they have to make a harmless error argument as part of their brief on every issue. So it seems to me that the limitation constitutionally in California is a limitation on the court.
I agree, but where we might part ways, Your Honor, and I hope we don't, where we might part ways is whether it's a limitation on the court in connection with state errors or federal errors. It certainly is a limitation on the court with respect to state law errors, and that's why in my briefing I conceded that as to a state law error, the Attorney General's complete silence in their brief about harmless error does not forfeit the issue. Now, there may be concerns in that it doesn't forfeit the issue because it's my burden to establish prejudice, and the miscarriage of justice provision in the Constitution precludes this Court from granting relief.
Can I ask you, counsel, just in terms of terminology, when you say it doesn't forfeit the issue, I understood you to mean in your briefing that it doesn't preclude the Court from reaching the issue. But the issue has been forfeited one way or the other, meaning the Attorney General has forfeited her opportunity to argue the issue. But that doesn't preclude us from deciding it anyway. Similar to a situation where if you filed an opening brief in this court and the respondent decides to file nothing, well, the respondent has forfeited a bunch of arguments. But that doesn't mean that the court can't then, in addition, decide those claims based on the best judgment we have on the record and the law. Isn't that similar here, which is to say that the provision Justice Corrigan alludes to in our Constitution may require us to address it. We can get to that in a second, but it may require us to address it. But the issue has been forfeited by the Attorney General.
I agree that's an accurate characterization of what I was trying to convey in my briefs. As to the state law error, now, there may be a problem with the adversary system because if the state has forfeited its right to make an argument and the court must nevertheless go ahead and resolve it under state law, the question is the court's put in a difficult position. It must then resolve an issue which the Constitution requires it to resolve without the benefit of adversarial briefing. And that problem can be solved by doing what this court did in this case, which is request supplemental briefing on the issue. I do agree, though, that there must be some consequence to not briefing it, and suggesting that the Attorney General can't argue the point is fine as long as the adversarial process is permitted to function in some way for the defendant.
Just sort of wondering, the federal cases you allude to reference a process. I mean, first of all, I don't read any of those federal cases to have ever permitted the government to rebrief the issue. Has that ever occurred?
In all the cases I have cited, I have not seen that,
Never
Your Honor.
seen it either. And so what the courts do is they do their best, right? They have the papers and the record in front of them, and they note the government's default, which is a forfeiture, and then they proceed in their discretion in federal court. I understand we may have a different standard here, but in federal court they proceed in their discretion to decide it on the merits, if they can.
Well,
And sometimes they can't because the record is too difficult. In other words, in a debatable case, like the Giovannetti case says, in a debatable case, the government's going to lose because they haven't borne their burden. That's under Chapman, right?
Yes, that's what the federal cases provide. Almost all the jurisdictions that hold this to be a forfeiture, and it is a forfeiture, will go on and recognize a narrow exception. And if you look at the case law and look at how that exception is applied, it's applied much more in the breach than in the observance. That exception is very rarely applied. It doesn't provide for supplemental briefing. It allows the court to go on and decide the issue if 3 criteria are met. It's a simple record. The harmless error question does not admit of much dispute, and a remand would be futile. None of those provisions would apply here to permit the court if it embraced the exception, and there are logical reasons for that exception, but none of those 3 criteria apply here, and the state hasn't even suggested that they do.
Can I, please?
I want to follow up on a question. So in response to Justice Liu's questions, you suggested that there should essentially be a balance. We should balance the adversarial system and the consequences that go with an asserted forfeiture. On the other hand, the court is entitled to ask for assistance when it wants. Is the way we strike that balance then, in the absence of briefing on this issue, to strike the Attorney General's brief because they had forfeited the issue, but to accept the assistance that you give us in the subsequent briefing? Is that how you would have us go forward?
Actually, no, Your Honor, it isn't. I might not have objection to that, but that's not what I've suggested. What I've suggested is that they have forfeited it. And as to the federal law issue, there is no the exception that is applied by the 13 or 14 jurisdictions does not apply here. The state doesn't suggest it does apply here. As a consequence, there's a forfeiture of the issue, and the penalty phase has to be reversed.
You're saying there's a forfeiture with respect to federal law?
Yes.
But not with respect to state law?
Well, with respect to state law, the court still has an independent obligation to resolve the issue under the miscarriage of justice standard. So if they say nothing, and if I've briefed an issue under state law, and the state argues that it's not state law error, but they make no harmless error argument, I cannot stand before you and say, therefore I win, as I think I can with Chapman error, federal constitutional error. The court still has a duty to resolve this. Now, the court, in resolving this, the question is, what happens to the adversary system? Because the state hasn't briefed it. So the court has solicited supplemental briefing. That's fine as far as, I think, as far as the defendant's right to provide the court with supplemental briefing. The problem comes is, well, how does the court, should the court be considering the state's position in the case as articulated only in the supplemental briefing?
I think, I know we asked for it, but in reviewing these papers, I read your papers, I read your opponent's papers, but I don't really see why we ought to have the second bite at the apple for either of you, actually, on the merits of the harmless error analysis. The issue was fully briefed in your original brief. The Attorney General chose not to respond to it, or it was her oversight, one or the other. We don't ordinarily give litigants a second chance to brief it. And there's no reason, as you say, a defendant would ever have that opportunity, whether out of intention or inadvertence. So I'm not sure why we ought to approach the issue from the standpoint that the supplemental briefs are giving us some information that I mean, of course, we're the court. We can ask for assistance, but we also should have even-handed application of the rules, right? And so when we have a default, we do our best based on the papers that have been given to us. We don't ordinarily cut the corner and then say, well, here's a second chance.
I have to
applies to you as it does to the Attorney General.
I
There's no reason you should have an opportunity to make additional arguments on the merits of the harmless error analysis in supplemental briefing, just as there's no opportunity for the Attorney General either.
I confess I would have been perfectly happy if the request for supplemental briefing addressed only the forfeiture question, Your Honor.
I know you answered our question, so it was we teed it up for you to answer. But
But I do see the problem that Your Honor has identified, and that is typically we don't give litigants a second bite at the apple, and that's exactly what's happened here if the Court goes on, and it applies to me as well, the briefing I provided in the supplemental briefing.
Well, how does this differ from what the Court occasionally does after oral argument? Something's come up and we ask for supplemental briefing. How is this any different?
The difference here, Your Honor, is I think what I'll call the principle of parity, and it echoes or gets back to what I started my argument with, and that is if I had suggested an argument that was new at the May oral argument, I would not have been afforded an opportunity to brief it. I would not have been afforded an opportunity for supplemental argument, and for good reason.
Do we know that? That both parties wouldn't, if it interested the Court and it seemed important, that both parties wouldn't have the opportunity to bring it to us in supplemental briefing?
In my experience, Your Honor, and I confess I don't make a practice of raising new issues at oral argument, because I understand that the appellate rules frown on it. So I cannot say that if I had argued it, the Court would have been hostile to it.
I don't want to detain you too long, but Mr. Gardner, I'm looking at a quote from one of our cases called People versus Hill, 3 Cal 4th 959. And here, in a footnote, defendant contends on appeal that respondent has conceded the alleged Bruton-Aranda error because respondent does not address that issue in respondent's brief. Are you familiar with the case?
I know the general authority.
And we
Your Honor.
reject this novel contention. We decline to find a waiver based on nothing more than respondent's failure to respond to defendant's Bruton-Aranda argument, which itself was raised for the first time on appeal. And there's more in the footnote, but how is that different than what you're arguing now?
I think the response to Hill is to cite, Your Honor, to People versus Bouzis, a case that came out 1 year before Hill, in which I'm familiar with because I was counsel in Bouzis, and the State did not address an issue, and the Court reached just the opposite conclusion to Hill and said, look, defendant argues this, the State has not responded, we view that as an implicit concession on the issue.
Can we choose then, since we have, you're telling me we have 2 California Supreme Court cases that seem to go on the face of it, different directions?
They do, and I think in choosing which way to go, Your Honor should be guided by the 13, 14, or 15 jurisdictions that have since faced this issue directly.
But not, you mean they're federal jurisdictions?
Well, they have, some are federal, some are state, but they have all addressed the question of Chapman error. Whether Chapman error, when the State doesn't brief it, whether the State has forfeited the issue. And uniformly, all those jurisdictions hold it is forfeited. There is an exception. Because let's face it, the elephant in the room and the fear that this and any court should have with respect to the forfeiture argument is the technical argument that a defendant makes in a long brief that the State inadvertently overlooks or inadvertently overlooks a harmless error argument, and boom, there's a windfall to the defendant if we apply a strict forfeiture rule.
Could I add to, counsel, isn't it the case that those cases, it's not that there's no federal constitutional miscarriage of justice provision, but there is a federal rule of criminal procedure, is there not, that says in equally mandatory terms, no judgment shall be set aside, or rather, I'm sorry, that's ours. The federal rule says any error, defect, or irregularity that doesn't affect substantial rights must be disregarded.
Yes.
That's a directive to the courts, is it not?
Yes,
Yet
it is.
the courts find that this is a substantive command that's layered on top of the usual procedural rules. The procedural rules are not displaced just because you have substantive commands. That's a typical presumption in the law.
It is. And if I can, let me just focus for one more moment on the exception in federal court, because it is there to deal with the case that's covered by this rule and the case that any court should be concerned with, the technical violation, the overlooking of something, the windfall to the defendant. That's what the exception is there for. I have no problem with an opinion that embraces the 13, 14, or 15 jurisdictions and adopts the exception. But in any event, that exception doesn't apply here.
Well, let me ask you how that would play out in real life. So
I'm sorry, Your Honor?
let's discuss for a moment how it plays out in real life. I know we try not to be concerned with real life here in the courtroom, but just as an aside. So in a death penalty case, the defense raises 70 issues. The ascribing error to each of them. The Attorney General responds on the merits to each of those issues and says, no, this actually isn't a violation of this rule, and the hearsay was properly admitted, and all of those other things. Is it your position that the Attorney General, in an abundance of caution, then, at the end of every substantive addressing of every issue raised by the defense, then also has to go on for a couple of pages to brief why it's harmless error? If it is error, it's harmless for 70 or 80 issues? That seems odd to me.
I appreciate that. And the last thing I would do is want to burden my colleagues in the Attorney General's office with more
and
make
they
work.
Appreciate that.
Just for the record, Your Honor. If they genuinely believe that an alternative harmless error argument should be made, they should make one. And it shouldn't just be a rote sentence. This isn't about adding a macro to the word processor that says, and in any event, it's harmless under Chapman and it's harmless under Watson, and therefore we're covered. If they genuinely believe an error is harmless under the federal Constitution, they should make that argument. If they don't...
Good advocacy would seem to indicate that all of us, when we were trained as advocates, say, make your strongest argument, and don't say, and by the way, my dog, I don't have a dog, so he didn't bite you. You know, it seems as though you're suggesting that an advocate who has a strong point and believes in the strength of their point should also undermine it by suggesting that even if I'm wrong, I win anyway.
Actually, it's just the opposite, Your Honor. I'm suggesting that the Attorney General's office should make the same decisions I have to make every day as an appellate lawyer and as the members of the bench had to make when they were arguing. You make a decision tactically what your best argument is. If you have an argument that's not credible, you don't want to risk your credibility with the court, so you don't make it. But if you have a credible argument to make, you make a decision to make it. If you make a decision, and it happens to criminal defendants all the time, Your Honor, if I make a decision not to raise an argument because I think I have a better argument here, this isn't as credible, this will undercut my argument, those are decisions lawyers make all the time, and their clients are held to those. At least my clients are held to those decisions when I make them.
Mr. Gardner, before your time is up, for my benefit, would you summarize how we are supposed to accommodate Article 6, Section 13 of the California Constitution with what we're faced with here?
I confess, Your Honor, Article 6, Section 13, perhaps some language of the provision that I'm supposed to accommodate?
Oh, that we have a duty to not to reverse unless there's a miscarriage of justice. I'm sorry.
No, I am. I'm sorry. I didn't realize we were talking about the same constitutional provision. I just wanted to make sure I wasn't about to accommodate a provision I had no idea of. I think the answer is this. As to state law errors, that miscarriage of justice provision in the California Constitution means that if the state does not brief harmless error, they have forfeited their right to make the argument, and the court must nevertheless resolve the issue. Whether the court in a particular case wants to solicit further briefing from the defense is, because there has been no adversarial testing, may be something the court wants to consider.
Okay, that's good. That's point one.
At point two, as to the Chapman error, the state provision dealing with state law error has no bearing on the question of whether forfeiture has occurred by failure to contest prejudice, because as to federal constitutional errors, in contrast to state constitutional errors, the burden is on the state. The entire reason that I believe the court has to go forward and resolve the state law issue, even if the state doesn't brief it, is because the burden is mine. At all points in state law errors, the burden remains with me to prove the error prejudicial. But that concession comes with something else, and that is when the burden is on the state to prove the error harmless, when they don't step up to the plate, when they've made the tactical decision to contest error but not prejudice, then in that situation, as all the courts have held, that error is forfeited.
And this would be a new rule in state court.
Well,
California, it would be a new rule, would it not?
there are a number of California cases. Bouzas and Hill are the only California Supreme Court cases. There are a number of lower courts of appeal that have, in fact, held that if you don't step forward and brief a harmless error, it's waived.
So we couldn't look at the record ourselves and conclude without the input from the state that the error was harmless beyond a reasonable doubt, assuming there's error.
Correct.
We're not able to do that. There's something wrong with that when the larger purpose is justice, if you will.
We don't need to write so broadly in this case, do we? I mean, there may be some clear cases in which the record is not very big, the evidence is not very complicated, and the court can, in its independent exercise of review, just decide it in the same way that we, I gave you the example of the unfiled brief. Yes, I mean, it's imperfect, it's not adversarial, but the court can decide it. Here, in your case, it's not Justice Corrigan's hypothetical of 70 issues. You didn't hide this issue in your opening brief, did you? It's prominently featured in your opening brief, is it not?
This issue is the first argument in my opening brief past the voir dire issues. It's the first argument in my reply brief past the voir dire issues.
Absolutely no trap set for the Attorney General in this case. There's clear notice, and there's a forfeiture. So, and the evidence in this case, if we could spend just 1 minute on that, is somewhat complicated, it seems to me. I did read your submission, and I did peek at the Attorney General's submission, though I'm suggesting we shouldn't. It's complicated. Can you, I mean, what I don't understand about the evidence is, what role does Jonathan Howe's testimony play in the, at least in the penalty phase, if we could focus on that for a second? Both your briefs sort of focus on this issue, and I must say I find it hard to come to a clear view about that. Can you just summarize what the importance of that is?
I can summarize
the excluded statements, how they bear on that.
I can summarize the importance of Jonathan Howe, but if I can begin the response by responding both to your concern and Justice Werdegar's concern expressed to me a moment ago, I appreciate why it seems difficult that there's this strict forfeiture rule. And that's why those courts have developed the exception for the cases that are simple, where harmless error is easily resolved. But there's another issue, and I know Your Honor is looking at this case. But courts of appeal don't necessarily have the luxury. I know in answer to some of the students' questions this morning, we talked about how many cases the courts of appeal resolve. They don't always have the luxury of asking for supplemental briefing and supplemental argument in all these cases. That would be a very difficult rule to apply. And so when thinking about how someone else mentioned this morning the idea that the court thinks about going forward, in thinking about going forward, that's why so many courts have embraced this rule of forfeiture with a narrow exception to avoid the windfall to defendants. And that brings us to the second part of your comment, Justice Liu, and that is to talk about the facts in this case. It was a 15,000-page record. This was not you expressed some concern about how the harmless error analysis works. That's a legitimate concern because it is a complicated record. As to the specific question about Jonathan Howe, as to the penalty, the jury heard statements from Jonathan Howe that he said Mr. Grimes admitted ordering the killing, watching the killing, and enjoying watching the killing. Just imagine for a moment how powerful that is to a jury deciding whether Mr. Grimes should live or die. He ordered it, he watched it, and he enjoyed it. Extremely powerful aggravating evidence.
Let's say that I agree with you temporarily for the moment. Was defendant required to renew his motion for the penalty phase? And if so, did he?
To renew his objection, Your Honor? I'm sorry,
No,
his
motion
proffer
to
of evidence.
admit this evidence.
The answer is no, because the trial court had made, and I think we actually discussed this in the May oral argument, Your Honor. The answer is, not you and I, but the court. The answer is no, because, in fact, counsel had offered the evidence. The trial court had said this is inadmissible because it's not a declaration against penal interest. Nothing had changed in the interim.
So he wasn't required to renew it because it had been definitively ruled against him?
Exactly. It had already been ruled against him. It would have been futile to renew the evidence because the court had already ruled it inadmissible.
All right.
So the power of that evidence that he ordered the killing, he watched the killing, and perhaps most aggravating of all, he enjoyed watching the killing, is all undercut by evidence that was excluded that, in fact, at the time of the killing, he was in another part of the house, didn't see it, and came back and was surprised. I realize there are competing inferences and competing arguments that can be made from all the evidence. But that's the problem here, is that the defense wasn't permitted to make the argument to the jury that you do need to spare his life. He didn't watch it, he didn't order it, and he didn't enjoy it. And the court, in fact, the prosecutor, in her rebuttal portion of her closing argument, told the jury they've never given you a reason to doubt Jonathan Howe. There was a reason, but it was excluded.
Did the defense impeach Jonathan Howe otherwise?
They tried to, Your Honor, yes. He was a jailhouse inmate, and they did.
Isn't that powerful?
They did their best to impeach him. Why wasn't it powerful? I think the best answer to the question of whether it was impossible is, well, if it was really a powerful impeachment, would the prosecutor have relied on Jonathan Howe solely in connection with the intent to kill issue? Prosecutors don't do that. Prosecutors are there in court. When they see that a witness has been effectively impeached, they don't tell the jury, my intent to kill theory as to the special rests on Jonathan Howe, who we all know has been impeached. They don't do that. He would never have relied on Jonathan Howe as the exclusive support for the intent to kill theory had Jonathan Howe actually been impeached.
Mr. Gardner, you may answer the last question, but your time's expired.
I know it has, Your Honor.
Well, is this a question of the trial court's discretion in drawing inferences and excluding or admitting the evidence? I mean, because there are other conclusions which a trial court drew about the nature of this evidence and what it could mean and whether it was mitigating for defendant. So is this a discretionary ruling?
I don't believe so. I don't believe the court excluded the evidence because the court didn't feel it was mitigating. The court excluded the evidence because he didn't feel it was against Morris's interest.
You're absolutely right. And does the court have discretion in making that call? I mean, you can draw different inferences. Are we supposed to draw an inference based on your argument different from the trial court's inference?
Well, of course you are, Your Honor, but let me actually give you a better reason than just it's my argument. In the Carpenter case, this court talked about how probative it was for evidence that, in fact, a defendant acted alone during a killing. It's terribly probative. It was relevant evidence under circumstances of the crime that made him more culpable and deserving of death. And that's exactly what Morris did here. He made statements that, under this court's analysis in Carpenter, made him more culpable and deserving of death. Those kind of statements are exactly the type of statements that Section 1230 says should be admitted.
Thank you, Mr. Gardner.
Thank you, Your Honor.